Hello and warm welcome to everyone at this third panel of the first day of the conference in commemoration of Marco Biagi. Maybe I'm not intrusive if I first mention my non-relenting gratitude for the gift of the life to know Marco, his huge capacity and the dedication. He visited Hungary already in the 1980s and probably felt the wind of the changes, and he contributed a lot to the changes, the revolution and innovation of labor law in a crucial period of transition to a market economy. So he was helping us in so many different ways, having a strong compassion for countries. And not in the second rank, I would like also to say a thank to the panelists, because it's a great pleasure to see the interest and let alone the very good papers, innovative research and presentation on the various sides of this issue we will discuss. We are a continuation of the first two panels, in the sense that we are dealing with the employment and the self-employment status, the changes, the borderline problems. However, at the same time, this panel is also a shift from the previous ones, because here we will discuss a different framework, namely the issue of collective protection. It will be addressed in this changing groups of labor. So this will be another borderline, namely between labor law and competition law. I would like to give the floor to our first panelist, Joanna, who you can see the very, very witty and much telling title of her paper, Abandon Hope, all who press enter here. And indeed, that tells a lot about her suggestions, analyses, collecting ideas and proposals on the collective protection of platform workers after having categorized them. So, Joanna, please take the floor. Sorry, I haven't mentioned that Joanna Unterschütz is from the University of Business and Administration in Gdynia, Poland, and also she is a member of the TTUR group, the Transnational Trade Union Rights Group, working for and assisting a lot the European Trade Union Institute and Confederation. So I stop, and Joanna, please take the floor.
All right. Hello, good morning, everyone. Good afternoon, everyone. I realize that we are probably in different time zones as well, so it makes the conference even more exciting. Thank you very much for having me here. And well, my task is to talk about collective rights of platform workers. And as Csilla rightly mentioned, well, I think that the departure point for these reflections is a little bit pessimistic, because if we looked at the situation of platform workers, I would say 4 years ago, 5 years ago, there was practically no hope that those people could be represented as the rest of working people. But I think that now situation is changing very much. So that this is the reason why I gave the question mark in the title of the presentation. But before we say a little bit more about collective bargaining, what I think should be mentioned at the very beginning is that, however, very often when we talk about platform workers, when we mention platform workers, we talk about, well, the name platform workers, but as if they were just the same, but they are not. Platforms are very different one from another. There are various classifications of platforms depending on, well, focus, but they are very different from one another in terms of organization, in terms of their purpose, in terms of how work is being performed, how work is being managed. So we may have our picture of a platform worker, for example, the Uber driver or AMT worker, but that's not actually true. And this makes things even more complicated, actually, because it's very difficult to talk about like unified worker status of a platform worker. I'm not going to go into that because it's opening a Pandora box. But well, then it is very difficult to talk definitely about the way platforms are organized. But what we see that most of the platforms have in common is the usage of so-called algorithmic management methods. And that means for workers that, first of all, their work can be tracked, their work can be monitored in many different ways, and these monitoring techniques can get into their work, their lives, the way they are performing work very deeply. And it is very difficult for them to very often see the mechanism. What are those algorithms doing, how they are managed, how they are organized, how come that I am evaluated in this or that way. So very often we talk about black box of algorithmic management, something that worker actually cannot see. Another feature of that is the way the work is evaluated, and very often the task of evaluating work is done by the clients, not by the platform, but then how the evaluation system influences workers' work, remuneration, or even disconnecting him or her from the platform is a matter of an algorithm. So this is one of the common features, and this is to a certain extent something I'm also building on. Why? Because those algorithmic management methods are based on multitude of information that are gathered from the workers and that are somehow then managed and used for the purposes of management. But what I think could be an avenue for the workers to use in collective bargaining is to actually use the information. They would not be probably able to use the information directly, but one of the ways that could make the information that are gathered from workers, that are collected from workers, from how they are performing their work, is to use the API technology. And this is the technology that allows sharing information between, well, for example, between companies and clients. API technology is, for example, used in by booking companies. It is used by security companies. So it makes it possible to, first of all, share the information and then make use of the information by another party. So that can be used to manage working time of platform workers. That could be used also to conduct automatic negotiations on wages as well by the workers. And I think that this is one of the avenues that maybe, perhaps it is already used to a certain extent, but it could be used more, given that there is so much information going from worker to platform and vice versa. Of course, when we talk about challenges to collective bargaining of platform workers, we have to bear in mind that, well, one of the conditions to bargain collectively is to unite. And this is something that, well, actually does happen among platform workers. They do unite. They They are unionized now more than they were 5 years ago, but still representation of platform workers in trade unions by trade unions is very small, is very limited. We could say, well, no wonder, because this is also the case of many precarious workers, many atypical or much atypical workers, but I would argue, I would say that in platform work, given its characteristic, given its nature, given the distance between workers, for example, it is even more so. Well, as a consequence, the representation is even less, even more scarce. But if it happens, if platform workers manage to unite and manage to go together, they start to bargain collectively. And there is already an evidence of employers negotiating on use of artificial intelligence, on use of big data at the workplace. And also there is an evidence of covering platform workers by collective agreement. Of course, the way it is being done differs from one country to another, from one platform to another, but it still happens. So from that point of view, I would say, well, again, there is a hope. There is a hope that something would develop in the direction perhaps more favorable. Also, when we think about collective bargaining of platform workers, we have to consider that there are some very specific issues, because, well, of course, there are some issues that are common for all workers, like, well, general employment conditions, fair dismissals, wages, of course. But what we have here for platform workers, it's also the question of, for example, imbalance in terms of access to information. This may be very often a problem for them because they don't know what's their actual situation at the workplace and how are decisions made. Then, of course, there is the issue of transparency in the ratings, because very often their position at the workplace depends on how they are rated by the clients. Then there are some specific health and safety risks that may stem for example, long hours of sitting in front of the computer, but they will be different for different types of platform workers. For riders on bikes, it will be different than for drivers, and for people who, for example, take care of children or elderly people. They will be just different, but they are a little bit specific, especially that I can't really imagine a decent health and safety training for platform workers. Well, perhaps it does take place, but, well, I'm not very hopeful in that regard. And, well, what we have here, of course, are also all the health issues connected to coronavirus, because especially for those platform workers who work with people, in the research that was made concerning this group of workers, it is mentioned that in many cases, what platforms did was to increase the way that they control what the worker is doing, for example, by making workers take pictures of their temperature, or that they're wearing masks or gloves, but well, not much more to protect their health and their well-being during that time. So to conclude, well, we have to acknowledge that the representation of platform workers is very limited, and that there is still deficit of formal social dialogue. Another thing that we see is that social dialogue that is taking place mainly on the company level, on the platform level, not on the sectoral level. There may be different reasons for that, but, well, that's the case. And, well, finally, what we could look at are, well, from one hand, some new technological avenues to research, and then also negotiations on the international level, on supranational level, because well, many companies, many platforms are companies working in, well, many countries, many continents. So this could also make some good fruits in the form of global framework agreements or another solution like that, or soft law. So I think that my time is out, and in order not to take too much time to my other colleagues in the panel, I would like to thank you, and I will be very happy to, well, stay until the end of the panel, answer questions if there are some. Thank you very much.
Thank you, Joanna. And now I would pass the floor to Silvia, who also will address the issues of this changing status of the various relationships. For me, I think the issue that is from a collective aspect, but Silvia, who is our colleague, probably, if I may say that, Silvia, with the TTUR group, because she is at the European Trade Union Institute, with whom we closely work. And she addresses, I think, in a quite broad aspect, this questioning the adequacy of the current legal framework with regard to the scope of application of labor law. And that was already, I think, mentioned by Manfred. I don't know whether you have heard the conversation after the previous panels, and also he referred to Alain Suppiot, who elaborated 20 years ago, or more than 20 years ago, a kind of new framework. And when reading Silvia's paper, I also put me here the note with the acclamation climb that was Suppiot already, but somehow it was not taken into consideration. Here again, the novelty of the paper is addressing the whole question with respect to the collective question, collective protection, collective agreements, how it is adjusted, how it can be adjusted to competition law issues. So Silvia Rainone has the floor now.
Thank you very much, Csilla. I am trying to, voila, I hope you see the presentation, you can hear me. So first of all, thank you very much, Csilla, for your nice presentation and for the remarks on the paper. Indeed, I probably was a bit too ambitious to try to collocate my reasoning next to those of, well, people have a lot more experience than I have, like Manfred or Suppiot, indeed. But let's try to not, let's try to say something as well in this context. So as Csilla mentioned, in my paper, I try to tackle the issue of the scope of labor law, and as we are talking about this topic about collective bargaining, and to see what can be done in order to allow self-employed workers also to have access to collective bargaining. And it was quite interesting in this year, actually, in 2020, 2021, some interesting development is happening in the EU legal framework in respect to competition law. Indeed, the Commission is thinking to, the Commission is thinking to adjust the scope of competition law in order to allow certain self-employed to have collective bargaining. And therefore, this sets the ground for reflection, which I will try to make. So I will start with a very brief presentation on the fact that, as we all know, labor law is within a changing world, and there are certain disruptive factors that may prompt us to reconsider the normative framework. One, of course, has been mentioned by many today, is the digital economy, so new forms of work. The other is, of course, always the increased globalization and the broader downward pressure on labor standards. And then we have a cyclical economic crisis, and this year we have a very big economic crisis connected to COVID-19. And all these factors, of course, also have an effect on labor policy. And we actually, quite interesting, so that recently has been considered to broaden the access to labor law and to social protection law, also to those not having the status of employee, but also indeed of autonomous workers. Looking at the initiative at the EU level, as I mentioned, there has been one which is particularly interesting for this topic, and is the fact that the Commission has launched an inception impact assessment and a public consultation on deciding, on brainstorming in a way, on how competition law could be reformed in order to allow self-employed to have collective bargaining. Because, as a reminder, at the moment they are not allowed to, because self-employed, to simplify the topic for the EU Competition Authority, self-employed amount to undertakings, and therefore they are prevented to, let's say, collude and stipulate prices. So this setting and the fact that there is a changing scenario is prompt me to consider whether is it maybe the moment to formulate a new paradigm. And then is where my paper becomes a bit ambitious, because while the normative changes have highlighted the fact that the traditional normative categories, such as those of self-employed, employee, workers, or other intermediate categories, are not very useful at the moment for the normative and the regulatory actor to determine the scope of labor law, collective individual labor law, but also market regulation. And these we saw with the competition law problem. So indeed, I mean, I thought that the current institutional debate on the scope of competition law could allow us to explore a bit what can be done in order to give access to collective bargaining to all those who need it, among which also eventually autonomous workers. And so, going on, yeah, sorry. What is the, first of all, in order, before try to set up a new normative framework, I think that the best way to proceed is to try to understand the problem. And regarding competition law, the problem is that for market regulation, all those who basically all those who are not employees and set agreement regarding price or other arrangement that may have a repercussion and effect on the market are considered to be anti-competitive and therefore are forbidden. This includes also the situation whereby self-employed are trying to collective bargaining their wages or other working conditions. Whether this is not only a doctrinal problem is highlighted by the fact that actually there are many trade unions and since years have organized, have represented self-employed, trying to improve their working condition. And this is visible and is evident in some sectors more than others. And I may remember the sector of journalism or entertainment, of arts, or translator, interpreters, all these sectors. Indeed, when looking, for instance, at the consultation process that has been opened by the Commission, we saw that those sectors have intervened more than others and have clearly explained the fact that with the current competition law rule, the lack of access to collective bargaining implies that they have absolutely no chance to impose decent working conditions, decent wages vis-a-vis their contractor, which have a very strong bargaining power, and often are market leaders, a very strong intermediary, which are able to set very low rates to which they have to abide. So the current situation imposed to these self-employed very precarious working condition, and also prompt the regulator to do something. What has been done till now? Well, not much, if we consider that the Court of Justice has tried to tackle the problem. We remember the Van Kunsten case, where indeed this conversation, this debate was opened. And well, the Court of Justice did try to approach and try to solve it, but did not manage to go beyond the classic distinction, dichotomy between self-employed, those who are indeed under the scope of competition law, and workers or genuine workers, those who instead are within the scope of collective bargaining and labor law. So the Court of Justice attempted also with the Yodel order to broaden the scope of the concept of worker, but did not manage to go beyond this dichotomy. So what I will try to suggest is to indeed break through and try to reformulate and try to see, try to go back to the origin in a way. So if we really have to think a new paradigm, I think the first step is to go back to the normative function of collective bargaining and think what is indeed the reason why are we reconsidering expanding the scope of collective bargaining beyond those who are in employment relation. And the reason is because historically collective bargaining has the function of strengthening the bargaining power, of course, of the labor, the worker part, the weaker parties, the worker, vis-a-vis the strong bargaining power of the employer or the business. And we see that now this situation, of course, does not only pertain more to those who are in employment relationship. As the testimony of those who replied to the Commission consultation prove, this stronger bargaining power of those companies who are in a sort of monopsony and therefore are able to set the market condition and the labor condition of their contractor, are having a very disruptive effect on the labor condition, on the wages of the person who perform labor, regardless of the status. So this considered, and I think that the real question to ask in order to determine the distinction between collective bargaining, right to collective bargaining, and market regulation, so competition law or all other sphere of economic regulation, is the real question is not to ask is that a worker or is that a self-employed, but the real question is, oops, the slide went away. Let me try to put it on. But the real question to ask is whether the contractual arrangement pertain to work or whether to the provision of goods and service. In other terms, are we talking about something that is subject to market rules, such as the provision of service of goods, or are we talking about something that pertains to the realm of collective bargaining, which is labor? So this is, of course, quite theoretical, quite doctrinal. It recurs, it relies on going back to the origin mentality, and it's difficult to summarize in a bullet point on screen. But it's nevertheless useful to think every time there is a contractual arrangement or contractual negotiation, whether the object of this contractual negotiation has a direct impact on the working condition, or is instead relating to the provision of a service indeed, or does this contractual arrangement have direct impact on the possibility of the person that perform the work of having access to the economic fruit of his work, of his activity. So these are, of course, the doctrinal questions that I think would be just nice to put forward, and this food for thought. I don't absolutely aim to give any final answer. So, and nevertheless, I try to put some indicators down in order to be able to identify what is the distinction, because of course they are very confusing situation. Let's think about, for instance, a translator who works as a freelancer and is asked by a university, because we are all in that field, by contract to provide a translation of work. Is that service or is that labor? Does this translator has right to collective bargaining, its tariff, its price, or not? Well, thinking along this line, I came up with a certain, not me, I mean, I borrowed these ideas from others who reflected way better than me, and I noted down a couple of criteria. And the first is about personal work. So we can assume that when a person, when a self-employed freelance perform work which is personal for a business, not for another person, then we are within the realm of collective bargaining. Instead, that of course cover one of the biggest issue, and the issue that have been showed by those who are the more considered by the European Commission the most vulnerable collective, self-employed. So let's talk about journalists, let's talk about interpreters, platform workers, and so forth. However, reducing this paradigm only to the indicator of personal work may not satisfy the full picture, because this will neglect the fact that in case of monopsony, or in case of company having such a strong power on the market, being able to determine the condition of the provision of services, and therefore the condition of provision of labor, it could be also interesting to think about other criteria. So whether, even in case the work is not only performed by a solo self-employed, and these criteria are whether the contractor that provides work act in the same market of the other contractor to whom the work is provided, or whether the service which is provided is necessary for the economic activity of the other contractor, or whether indeed the contractor, the service provider, that is not able to determine the client final tariff. In this sense, we can also think of the other fifth example of whether the tariff is collected and redistributed by an intermediary. So all these indicators suggest that even in case of absence of a solo self-employed, but even when we are in a situation of that goes beyond the sole self-employed, and we are therefore in a situation of strong market imbalance, those indicators may suggest that even in this case, collective bargaining, collective agreement may also regulate the term of the agreement which is between the service provider and the business contractor. So this is probably sounds a bit too complicated, but indeed is just food for thought and for trying to broaden the field of application of the right, which is this situation one of the most important one in order to achieve a decent working condition for all those who work.
Excuse me, sorry, Silvia, we have to finish because
I'm so sorry. Indeed, I am finished. I'm over. So that was the conclusion. Thank you. I'm really sorry for going over. Thank you, Csilla. I'm sorry.
Oh, okay. Thank you. And tremendously sorry, Silvia, for pushing myself to do this. But yes, I saw you were at the sixth slide already, so I hope that there was not much left. And now I would shift the floor to Ron Brown, as we already discussed here in the break. He is from University of Hawaii in the USA, and the particular interest in his paper is a view from a totally different system, nevertheless addressing the same problems. And I particularly liked here again the strong stand against inventing a new category, a third category beyond this parallel self-employment and employment. But also it was a very interesting thing with regard to the very special collective bargaining system in the United States, that here even collective bargaining could go through algorithm. If I'm correct, for me it was extremely strange, and I'm sure it will give a lot to help. I found a lot of ideas in the American system that could be taken over because not contradicting to European legal system, could be adjusted. So thank you very much for your paper, Ron, and you have the floor.
Well, you gave such a good summary. I don't know if I should continue. So I hope Francisco is listening, because I'm a bad student on Blackboard, and I think he was going to put my PowerPoint up. Francisco, if you're listening, you can put my PowerPoint up. Unless, are we supposed to do that ourselves? I don't know. Oh, there he is. Great. So my heart is in Modena, but I'm sitting here in Hawaii, so I'm sorry. So my paper was originally written for last year's conference. So I was coming to the table with good news in the US about gig riding, gig ride sharing drivers, very progressive legislation. California drivers were presumed to be employees and dependent employees and allowed to collectively bargain. Seattle, Washington, there was a new independent contractor law that allowed these ride-sharing drivers, the Uber drivers, even as independent contractors, because they were independent contractors, the right to collectively bargain. So now, lucky the conference got postponed, because 1 year later, Uber spent $150 to $200 million to overturn that progress by superseding legal means. So California, there was a ballot initiative that wiped out the ABC presumed employee status. The drivers did get some statutory benefits. In Seattle, the litigation continued with Uber, and they finally settled, which basically eliminated the collective bargaining law in Seattle, but some benefits are provided by law to the drivers. So due to the COVID delay of the conference, 1 year later, I report that because of Uber bullying, which slowed the progress of some of these breakthroughs, I report not the good news, but the hope, because there is a bill in Congress that could create dependent employees under the ABC test. So let me start by learning how to move this thing. So there we go. Oop, how do I go back? Thank you. So it seems to me at this conference on this subject, everybody's basically talking about the same thing. There's a problem. They got all these gig workers, and they don't have all the rights that regular employees have. So what do we do about it? So in the US, there appears to be an approach where you can create these presumption of employee status, create dependent employee status through these ABC legal tests. And there's a lot of states in the US that have that ABC test, not necessarily being applied to the Uber drivers in a consistent manner. Alternatively, as was done in Seattle, you can have independent contractors, these business people, independent contractors, and grant them collective bargaining rights per the American state laws. Can't do it on the federal level for reasons I'll explain. Okay, so am I able to turn the pages? Doesn't seem to, here we go. So go back one. So as you look at gig workers, so as other people have talked about, gig workers is such a big word. There's so many different kinds of gig workers. So chances are there's, in my opinion, there's not one legal solution or legislative solution for all the gig workers. Maybe there is, but for employee status and granting some benefits. But for collective bargaining rights is what I was zeroing in on more. I chose the Uber and Lyft drivers, the rideshare drivers, because they're kind of a coherent group, and there's a couple million of them. And so some relief to that group could prove useful. So you can turn the page. Francisco, thank you. So what we talk about most of the time here, obviously, is the employment relationship, the employer-employee relationship, traditional tests. I'm not sure if it happens in Europe, but in the United States, Uber and Lyft lobby for legislation. They call them carve-out legislation. Carve-out legislation carves out Uber and Lyft drivers and labels them by legislation to be independent contractors. So it says no way can they ever be employees because by law they are independent contractors. So that cuts off the presumed employee status. However, if you would use the Seattle approach and grant independent contractors the right to collectively bargain, that choice is still open if the state or municipalities would pass that type of a law. So the federal law, as Susan mentioned off screen, there's an act in Congress. I hope President Biden uses the shortcut method to get it passed, but we'll see. Otherwise, the state laws, some states create presumptions under the ABC test. Okay. So this has become kind of, we can study this at some other time, but so the Seattle statute sets up this collective bargaining relationship at the municipal level, and it's under a commerce department. So it's not like a National Labor Relations Board or anything, but they create this network of operation that it operates a little bit like a National Labor Relations Board and grants a certain scope of bargaining and certain protection for the employees and arbitration and things like that. So that's on the that was on the books till the litigation settlement set it aside. Okay. So in the U.S., like the EU, we have antitrust issues, fairly complicated, but there are exceptions. So if you're talking about a federal law permitting the independent contractors to collectively bargain, you're granting employers the right to get together and fix prices in violation of the antitrust law. So there's a problem there. So there's an exception for state and local governments who can do that. And they can do it, and they're not preempted by federal law because the federal labor laws exclude independent contractors, so there's nothing to preempt. So it can be done. So here's the model ordinance. So I hope sometime in the future that the states and municipalities in the U.S. will take a look at Seattle's law. It seems to me a fairly decent model. It rings all the bells on what a collective bargaining statute, in this case an ordinance, might lay out. Okay. Ding. So other options, if you're not an employee or an independent contractor that can collectively bargain, you can go for legal rights and benefits, as was ended up under the California proposition or the Seattle Fair Share Ordinance. The employees ended up with something more than they had. They got some health benefits and some mileage and some other benefits. And in the U.S., there's wage boards for public workers. They could create some wages. You could have a company union where the employer dominates it. Nobody much cares for that except employers. Sectoral unions is a nice possibility, except it's illegal in America. Solidarity unionism is a fancy word for saying take the streets and in a coordinated fashion do a coordinated protest, and Uber and Lyft drivers have done that consistently. Or you can do nothing and allow the big businesses to use their model to exclude workers from legal benefits. Okay, so globally speaking, the ILO wants to have most workers have benefits. The EU, there's so many experts in this conference. You can read my paper, see if I did okay, but I will defer to the expertise. There is a really good report that I like by Valerio Di Stefano, did a report studying some different countries' approach to this. And he ends up with the conclusion that there's a binary divide between employee and non-employees, independent contractors. And so you work within that and you try to organize the employee side, and maybe some of them are dependent employees. But on the independent contractor side, seems like there's not much room to wiggle. Maybe I didn't explore it that much, but it seemed like Ireland or somebody did some kind of a waiver or a carve out for on antitrust, but I'll leave that for the European experts. Okay. So China is kind of quick and dirty covering that. In China, you need a labor contract in order to have the right to any labor benefits and rights. Uber and Lyft drivers, or their Chinese counterpart now, are not given labor contracts. They're not thought of as being laborers that deserve a labor contract, and they don't call them independent contractors. They're just not entitled to a labor contract. Sometimes the companies use business cooperation agreements, business to business. You know, the big boys and the driver sign this business cooperation agreement because they're in business together. So they don't have any anti-monopoly problems over there, anti-competition cases in this regard. So in summarizing the U.S., I guess at this point I would say there's promise. The choice is emerging for these TNCs, or the platforms that hire and run the gig workers. So I think the choices that I wanted to present in my original paper was that these TNCs can accept these dependent employees under the ABC test as employees and let them collectively bargain. Or if you're in Seattle or another area where they have collective bargaining for independent contractors, if they're not employees, let them be independent contractors, but they still have the right to collectively bargain. But that'll require some new legislation and somebody to fight back the $11 billion Uber company and their lobbying efforts. In Europe, I'll defer to the wise judgment of all those who are at the conference. And China, I just mentioned. Okay. So lastly, I'm cautiously optimistic about the U.S. I think with this new president who's pro-labor, if he can get things through Congress, there's hope at the federal level for creating an ABC test and allowing for dependent workers for all these Uber-type drivers. And then if so, if not at the federal level and at the state or local level, to get to the point where a choice can be presented to the TNCs as, okay, if these drivers are employees, let them collectively bargain, give them rights and benefits. Or if you call them independent contractors, that's fine, but let them bargain under this local statute. So that's where I'll end. Thank you very much. Whoop, can't hear you, Csilla.
Sorry. Yeah, thank you. Thanks. I always forget this crazy microphone. Yeah. So thank you very much. And now I immediately shift the floor to Pärli. I don't know whether he is here. Oh, great. Hello.
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 And yes, thank you very much. And he is from Switzerland, the University of Basel, and his presentation will be about the autonomy and the need for more democracy in the world of work. And it was very interesting for me to read that through this how to say, algorithm governed work situation compared to Taylorism, he is oriented to a different direction, analyzing the situation very much from respect of democracy. Well, I wouldn't say now more. I made a lot of important notes from the paper, but it's better if you present them. Sorry, for some reason I hear my own voice very strongly echoed. I don't know whether this will be with other presenters, because then it will be very unpleasant for them. I don't know whether it's something with the microphone.
I can hear you perfectly. That's not a problem.
Ah, that's great. No, I thought maybe Francesco could do something, but that's okay.
Sorry, it's the next presenter. Sorry, it's next presenter microphone who is echoing a little bit of voice. So.
Oh, okay, that's okay. So then, please have the floor.
Thank you very much. I cannot see if you can see my video, but this is not very important. The most important thing is that you can hear my voice and look at the slide. So I try it again. Now, okay. The lecture I was supposed to have given in Modena a year ago has since developed into a paper that was accepted for publication by the Industrial Law Journal in December 2020. I will give insight into my work in the following 10 minutes, and at the end of my presentation, I will tell you where you can read the paper online. I first outline some general developments in the world of work in the light of digitalization. Digitalization is changing the classic relationship between employer and employee. This is well known, but this affects also workers' participation rights within the company. On the other hand, new forms of work demand very high self-organization and active commitment on the part of employees of problem solving and optimizing processes. But if at the same time management and organizational structures remain largely top-down and employees hardly have any say, this is contradictory. Digitalization could act as a catalyst for the dormant debate about democracy in the workplace. It is feared, however, that the talk of the democratic workplace will ultimately lead to even greater exploitation, mainly self-exploitation. The question of democracy in the world of work must therefore be posed much more fundamentally. It is not just a question of a few rights of co-determination. If we have an analogy between state and company in mind, then employees are citizens and have corresponding rights. The aim of MICA was and still is to identify paths of protection of employees also through participation rights. This also raises the question of which options exist beyond workplace co-determination. You will find now the table of contents of my paper on this slide. The technology-driven challenges in the world of work are explored in section 2, what is happening in the world of work. This is the section where I go deeper into the issues that was mentioned by the chair. So I make a comparison between Taylorism and the management in this period and algorithm management. Then I look more closely at the power gap between employers and employees, and I outline what I name the subordination paradox. After that, I look in deeper detail at the questions of co-determination, the democratic enterprise, and worker cooperatives, always reflecting technological challenges. I conclude finally about the need for the democratization of the economy. Let me say a few words about the subordination paradox. I try again to share the video. but this is not working. However, the concept of employment contracts is Janus-faced. On the one hand, subordinated work opens the door. Please go back. Yes. Subordinated work opens the door to social protection as a minimum right. Subordination opens the door to social protection of rights to minimum salary, paid annual leave, preventing dismissal, and the status as employee further guarantee a better social security coverage. But on the other hand, subordination means that by entering into an employment contract, employees subordinate themselves to an employer's managerial authority. And it's a paradox. The concept of private autonomy anchored in liberalism promises individual self-determination and freedom, but with the conclusion of an employment contract, the employee places a considerable part of his freedom in shaping his life in the hands of the employer. The employer can determine not only the execution of work, rather the employer's rights to issue instructions also includes on the conduct of employees, for example, with regard to trade expressions of opinion and so on. So without effective protection of labor law and collective agreement, this power of employers leads to serious threat to fundamental civil liberties of employees. At this point, there is a parallel to the necessity of the limiting state power. The legitimacy of state power, however, is based on democratic consent. Nevertheless, this is precisely what is lacking with regard to private exercise of power by employers. Or in a nutshell, please go back. Here. In a nutshell, you cannot be a free citizen vis-à-vis the state and some kind of a prisoner in the workplace. Democracy should not end outside the factory gates or in modern times when you log on into the company ICT network. I highlight in my paper that digitalization also offers the potential to revitalize some of the sleeping discourses about the democratization of the world of work, or even beyond, of the democratization of the economy. These debates concerned and continue to concern, on the one hand, participation of employees motivated by business management purposes, and on the other hand, the ensuring of co-determination rights at company level and through social partnership in labor law. Worker cooperatives owned and jointly managed by co-workers play an important role in the topic workplace democracy as well. For more and a deeper analysis, you may read the paper. I have these 3 cases: labor law related forms of employee participation, the democratic company as a business case, and worker cooperatives, the golden path to democracy at work, ? Let me come now to my final conclusions. So, the world of work may be at a crossroad. Digitalization could lead to greater opportunities to support the empowerment of employees, interlinking knowledge resources and strengthening various forms of democracy at work, within the company or shaped as worker cooperatives. Alternatively, if it came badly, new production models will create a control panopticon of employees' data, a huge loss of job stability, and a precariat at most skills levels. So there is a need for democracy in the workplace. Digitalization is one and important driver, but not the only one. Having subordination as the major criterion by which a relationship qualifies an employment contract is no longer adequate. Subordination is a precondition for social protection and has always been unworthy in itself. Digitalization only reflects this more clearly. Subordination under an employer's prerogative is hardly compatible without effective co-determination. At this place, labor law is required. How must the legal framework be designed so that democratic structures in the company and the protection of employees are guaranteed while the company remains competitive? Labor law studies have a major role to play here. Interdisciplinary methods and, above all, a constant view of legal reality are essential. Democracy at work is possible. Some very successful companies, some organized as working cooperatives, are proof of this. Nevertheless, as long as the employees have no access to strategic decisions and are not owners or co-owners of the company, democracy at work is only halfway there. Even worse, pseudo-democratic structure can cause self-exploitation. There are still lots of controversial problems. Democratic companies are acting in a mainly undemocratic economy. Therefore, digitalization and other recent developments remind us that there is not just a strong need for democratization at work and at the workplace, but there is a need for democracy in the economy as a whole. The idea offers a vision of an empowerment which could reinvigorate trade unionism and as a social movement and help launch a struggle for genuinely alternative economy. I thank you very much for your attention, and if you like to read the paper, you will find it on the internet site, which is presented at this slide. So I hope I have not spoke longer than 10 minutes, and I thank you for your attention.
Thank you very much for this very valuable presentation, giving us great ideas, and also, yes, you strictly observed the time. Thank you for that. And now I quickly pass the floor to our last speaker in the panel, Csilla Naumovitz from University of Warmia and Mazuri in Olsztyn, Poland. And again, we will hear about the autonomy, how much autonomy is in autonomous work, covering the legal status and social protection of freelancers in a national law in Poland. And we will also see some novelties that come from global level, from and also European level to the national one, innovations trying to adjust the legal situation to the deep changes. So Csilla, you have the floor now.
Thank you very much. I just want the confirmation that you can hear me and you can see me, because I had some technical problems before.
Yes, it's fine. We can see you, we can hear you.
Okay, thank you very much. I am very pleased to be part of this event. I am just terribly sorry that we couldn't meet in Modena in person, and not to lose more time because we have a little delay. I will try to focus on the most important remarks regarding the topic that was introduced, with relevance to the latest amendments of the Polish government to the Trade Unions Act in Poland. And as it was mentioned in the first panel, the question that is highly important to reply to is that there are different reasons, and these reasons for selecting self-employment were changing during the technical revolution, during the pandemic period. And we should respond to the question also considering the free choice or a necessity of so-called self-employed, sometimes false self-employed, or even truly self-employed, and the freedom of their choice and the consequences of their choice for the level of social protection that is granted to them. And as my colleague from Poland, Professor Unterschütz, that began this panel mentioned, I will refer to platform work, but platform work cannot be defined as one category. As misleading and inappropriate would be considering all types of platform workers as a unique whole. So my focus on my paper, that you can find also already published on the Marco Biagi website, I focus on one particular category of platform workers that I call freelancers, also referring to the Polish legal system that I will explain briefly in short. I am referring to the platform work that is not on location as drivers or Uber drivers or riders of Foodora, etc., but to high-skilled independent professionals that do the online platform work. And those independent professionals that are usually also referred to by the platforms as independent autonomous contractors or self-employed also have the same fundamental issues that were considered by different European rulings in the consequence of the claims filed by Uber drivers or Foodora riders in Spain, in UK, or in Italy. But what is interesting, and what was also a question that I wanted to examine a bit further, is that the voice of these workers, these highly skilled professionals also doing platform work, has not been heard that much. So I wanted to give the example of the legal action that has been taken by Polish government in the amendment of the Trade Unions Act, because it changed the personal scope of the right to associate and right to strike. And it definitely deserves a further discussion, because we have heard in many presentations of many previous speakers, also in previous panels, that there is a significant difference in the power of collaborative action or banking according to different types of platform work. So to give a little details about the legal status of those freelancers from Polish perspective and the case of Trade Unions Act in Poland, I have to shortly explain that in Poland we have no particular regulations of platform work so far, and the main forms of performing work are divided in the classical dichotomy between subordinate and autonomous work, with no recognized intermediate categories. So from this point of view, if we think about high-skilled online platform work, usually those freelancers engaged in this type of platform work would be considered rather independent contractors, or in some cases employees, but rarely. And the consequences of this fact is that they lack of social protection, including, for example, the protection of time of work, minimum wage, or the autonomy in the selection of clients or tasks or holidays. That is also the case of other types of platform workers. But what is also important from the Polish perspective, it's that on the Polish labor market, we have been observing for many years now an overuse of non-standard forms of employment, which also include the business-to-business cooperation, or the overuse of independent contractors that are supposed to substitute the traditional employment relationship, but reducing risks, costs, and responsibilities for the employers. So considering this phenomena, an answer that has been given by the Polish government, also as a consequence of the ruling of the Constitutional Tribunal, was the reform of the collective labor law. And in 2018, this amendment to the Trade Unions Act introduced a new category of persons performing paid work that have been granted the protection of collective labor law, and a person performing paid work has been defined as not only an employee but also a different type of person performing work for remuneration on other basis than employment relationship. And if that person does not employ other people for this type of work, regardless of the legal basis of employment, the person performing paid work other than employee has been also granted the right to be represented and defended by trade union, and also the right to associate in trade unions. And from that point of view, we can see that there has been a deep redefinition of the personal scope of protection in the Trade Unions Act. And by including other persons performing paid work on a different basis than employment relationship, it opened a way for collective bargaining for theoretically also platform workers that are considered by the platforms independent contractors. But the problem is that introducing this new terminology, the new term definition of the person performing paid work, this had led to different controversies and problems in the interpretation of those definitions of those new terms. And for this reason, we should bear in mind that there is a need for further specification and for the adaptation of the mechanism of protection that have been created for the employment relationship and now should be adapted to different forms of working performance, also including the platform work, the other non-standard forms of work, and the fact that if we considered that high-skilled professionals have generally, as the data shows, and different statistics that have been gathered, different research that has been made about the collective bargaining power of platform workers and independent contractors show that in case of high-skilled professionals, this power is low. So if we observe the actions taken by, for example, Uber drivers or Fubora drivers and their influence also on the legal regulations in different European states, we can see that there is a strong need for this type of protection and this type of representation of common interest, and that the right to association, to collective bargaining, to strike are not necessarily reserved only for employees. But definitely the Polish example shows that even introducing the new category and allowing the self-employed, also in this case platform workers, to participate in collective bargaining doesn't necessarily automatically lead to collective actions, because one of the problems that we have to address and that we have to think about in future, trying to find some solutions to, is how to adopt the mechanisms that we have to the particular needs and possibilities of collective representation and collective actions of these types of workers. Especially if we also consider now the deeper isolation of those workers from one another and the possible responses that we can give to these problems by using the same technology that they are using to perform work in order to communicate with each other and to organize themselves in some collective actions to represent collectively their interests against the platforms. So I just wanted to address some main remarks that I have addressed in my article. I would like to maybe finish with this short insight into the problematics, but I'm looking forward to some questions and discussion. And because it's late, I give the floor to other speakers, and thank you very much for this occasion and this presentation.
Thank you very much. And now I would give the floor immediately to Susan Bisson-Rapp, who I should not introduce, but there are lots of participants who have not joined before. So I have to say that she is also, actually, I think the indication at your name that shows not only your university, Thomas Jefferson School of Law in San Diego, but also that you are belonging to Marco Biagi Foundation, Italy. So I'm sure we will have a very interesting commentary on the 5 papers and the presentations. Thank you in advance.
Thank you, Csilla. Yes, the Marco Biagi Foundation has been for many years my home away from home, so thank you for noticing my connection. A couple of years ago, I co-authored an article with a Canadian scholar, Joanna Unterschütz, on the legal regulation associated with the destandardization of work, and we took a look at how governments and regulatory authorities contribute to, or on the other hand, prevent the decline of the standard employment contract. And we began by articulating 3 government functions that are central to the way that work is regulated. And I think all 3 of these functions are a useful way of connecting our 5 papers. First, the government plays an essential role in describing and defining the change in the labor market. Second, the government occupies a primary role as the protector of substantive rights in the labor market. And third, the government acts as an insurer against social risk and inequality. And we hope by focusing on these core functions and elaborating a menu of techniques that the state can use for achieving them, we can demonstrate the extent to which the government bears responsibility for the changes that our 5 authors here are writing about. More specifically, to the extent the government is passive or inattentive in the face of the rise of the platform economy, it leads to degraded work, and this should not go without comment. Failure to reckon with business models that allow those who labor, in some cases, to make less than the statutory minimum wage is a policy choice by governments. We want the state to be accountable for that choice. So let's think about those 3 core functions of the government in terms of the papers that we heard. Now, Camilla, Kurt, and Silvia's points about binary classification of workers being unhelpful and outdated and inadequate to the task of assigning substantive rights reminds us of the government's definitional role. To the extent the government is content to bifurcate the world of work into employees who are entitled to fundamental rights and independent contractors who are not, the government is not simply a neutral arbiter of reality. It is responsible for the effects that are created by that choice. Collective rights and representation for platform workers, which all the authors address, reminds us of the government's second role as an entity that protects and makes real fundamental and other labor rights. Ron argues strategically and pragmatically that ensuring platform workers can freely associate and choose representatives and bargain will advance the project of decent work. Joanna raises the issue of collective rights as a way to address occupational safety and health, what she terms dealing with technostress that occurs among platform workers. Silvia reminds us of the normative function of collective labor law. It aims to correct the uneven distribution of power between business and labor. And then finally, Kurt, Camilla, and Silvia make social protection central to their arguments, reminding us of the key role the state plays as the insurer against social risk. Silvia helpfully reminds us that the COVID crisis widened the reach of social protection made available to atypical, non-subordinate workers. Certainly we saw that kind of move with respect to the pandemic in the US. Our pandemic unemployment assistance program made available to individual states the option to extend unemployment compensation to independent contractors, freelancers, and the self-employed. It was a limited program for atypical workers. Only if they were unemployed due to the pandemic could they take advantage of it, but it is a demonstration of government action in the face of acute need. It's a demonstration that it's possible to improve the conditions of atypical workers. Now, all 5 authors together make convincing arguments that representation and collective protection for atypical working is a necessary corrective to degraded working conditions in the platform economy. Ron's paper, however, highlights the resistance that governments are likely to face when they attempt greater regulation of the platform economy. Lawsuits by the Chamber of Commerce and Uber followed Seattle, Washington's efforts to extend collective rights to those who work for the ride-sharing industry. Fear of triggering competition law caused the city of Seattle to drop as a subject of bargaining payment to the drivers, that absolutely crucial aspect of the relationship the drivers had to Uber and Lyft and other ride-sharing companies. In California, the government's attempts to regulate platform work by adopting an ABC test and a presumption of employee status for all workers, including platform workers, was met with lawsuits, a refusal by Uber and Lyft to reclassify their drivers. They just absolutely refused, and the state of California had to sue them. And as Ron mentioned, a $200 million ballot initiative to place before the voters of California an exemption from the new law for any company providing transportation and delivery services through an app. Well, that effort succeeded. Proposition 22 passed last November, and it created a 3rd category of worker, the gig contractor. Gig contractors in California will have a guaranteed wage floor of 120% of minimum wage. They will get a stipend to buy health insurance because we do not have publicly funded universal health insurance in the United States. And companies say that they will make available sex harassment and equal employment opportunity policies. But notably missing from this proposition and this new exemption to the California law is any right on the part of platform workers to collective representation. Ask yourself for a minute why that is a right that, in fact, we are depriving those workers of. We deprive them of it because it is such a powerful mechanism for improving degraded working conditions. So as we theorize about the need for representation and collective protection for the platform economy, we need to also account for the resistance of the platform companies themselves. How do we meet that challenge? That's a question I pose to our 5 authors. Thank you.
Thank you very much. And now the question is put to the 5 presenters, whether do you have any response to Susan's question or otherwise comment to the comments. Ron?
Well, I will mention that. So I've talked to the Teamsters, who is the union up in Seattle that's organizing the drivers up there, and they say they're they're working hard, but it's like herding cats because these drivers are spread out all over the place, and it's difficult, especially during these COVID times. And so not only is it hard to organize these people into a collective group for whatever purpose, for improving benefits or collective bargaining, is just tough. And so what you need is a counter force, and the union is the obvious counter force, but they don't have $11 billion like Uber does, or 100 million or 200 million to spend on these lobbying efforts. So the Seattle City Council somehow had this far-reaching idea to do something decent. And so I guess the answer might be to appeal to states and city councils where the Ubers and the Lyfts are heavily involved, and have them pass an ordinance to improve the situation for the drivers, either make them dependent employees or independent contractors with collective bargaining. And as Susan mentioned, in Seattle they did remove that wage provision to make Lyft flee from complaining about the monopoly and anti-competition, but it didn't work completely.
Thank you. And as I see, Silvia has the floor now.
Thank you very much. And yeah, thank you very much for the final comments. Indeed, that's an aspect I think no one really tackled directly, but it was a bit sidelined, but underpinning all our contribution. Indeed, of course, collective bargaining is one side of the narrative, one side of the story, because I'm fully convinced that without the support of the public sector, the government, of rule makers, well, there is not much collective actors can do, because the powers they have to countervail is so huge. I mean, we are talking about monopoly, we are talking about business influencing markets, and let alone labor. So in a very small setting, there is a very nice example, maybe comparable to those American examples, but in a very small scale, in the city of Bologna, where they signed this fundamental right charter of the riders, where the municipality indeed invited companies and worker representative collective to sign, and then anyone who wanted to perform, any platform who wanted to perform work in the city had to abide to certain rules. So of course the role of the state as mediator, as enforcer, as promoter is essential. So thank you also for that aspect.
Thank you very much. And Joanna has something to say.
Yes, it's just it's just to say that I absolutely agree with Susan about, well, first the role of a state, because, well, this is the state who to a large extent regulates, at least has its role in regulating status of worker. And, well, I didn't mention it because, well, it's a huge subject actually, especially for platform workers, but not only. But yes, the fact, whom do we formally recognize as a party who is capable to unionize, who is capable to carry on collective bargaining is actually essential. And of course we can go through this discussion from the perspective of the ILO, from the more general notion of worker, etc. But then if we come down to the level of a country and then to the level of a company, the regulation that exists is absolutely crucial. And this is, well, what my colleague from Poland, Dr. Naumowicz, was talking about. And, well, one of the reflections a little bit on the background of her paper is, well, it's very nice. It's really lovely that the legislator recognized the capability to unionize of non-employees, but it didn't end up with a multitude of workers being unionized. In fact, I think it's the change also in mentality, in approach to work, in approach to trade unions, etc. Well, all right, I'll end with that. Thank you.
Thank you. Thank you very much. And I don't see any hand in the air. I don't know whether Piera Campanella, do you have something to say? because I see, but it's unclear. Or maybe, but hand raised, select to lower. I don't know. Piera Campanella, do you hear us? No. Then probably there is no more. And considering that we have already exceeded our time, and I was already during Susan's comments a little bit afraid of being switched off, probably we have to finish now. Thank you very much for all the presentations and the very, very interesting comments. I think we will continue. I do not tell now my comments because it's really beyond the time. It would be an abuse of my position, and we are talking about justice. So thank you very much, and thanks also for the organizers and the technical commanders or moderators, and have a very nice evening. See you tomorrow.